So today, the talk that I want to deal with is obviously about COVID as a Barder event. What we will deal with, as little Boris is telling us, is what do we mean, firstly, when we actually say a Barder event? So looking at some of the original case law, taking a smattering of case law subsequent to Barder that's not exactly niche to COVID, because I think it's important to understand Barder events generally, and then looking at some COVID specific examples of Barder style events. And really, we're looking at dramatic economic change, then asking the $1 million question, is COVID a Barder event? Having a brief overview of variation. Under variation, I will take in the thwaite jurisdiction to vary executory orders, and then briefly touch on COVID. So lots to get through. I'll try to make sure no one falls asleep, and if everyone's sitting comfortably, I'll begin. So the case that started it all, Barder and Barder, really quite dramatic facts. Before going on to that, the concept of Bada, I'm sure anyone that's ever used the financial omnibus orders will be familiar with the concept, because under pension sharing, the standard wording now is that there is an agreement that if the person benefiting from the pension share dies before the order has been implemented, then the person whose pension is being shared has the consent of the personal representatives of the deceased to apply to vary or set aside the terms of the order. And so that really quite neatly sums up how Barder events really work and how orders might change. But going on to Barder itself, Decree Absolute was granted on the 25th of September 1984, and the parties entered into a consent order. It saw the wife staying in the family home with the two children, and it was on the basis that she paid the mortgage and the home was to be transferred to her within 28 days. However, on the 25th of March 1985, before the family home was transferred, the wife killed the two children and then committed suicide. And about just under a month later, 23rd of April, the husband sought leave to appeal, and he said the basis upon which the order has been made has been fundamentally and unforeseeably altered. The beneficiary of the order now is not the wife, is not the children, but is actually the wife's estate, who is her mother, who is Miss Caluori, who becomes the intervener. So the husband wins at first instance, goes to the Court of Appeal. The wife's mother wins at the Court of Appeal. And aside from the usual argument, she also argued that because the wife had died, there was no scope for the court to do anything because the suit had come to an end due to the wife's death. But then the husband takes it to the House of Lords and he wins. And we get the seminal judgment of Lord Brandon of Oakbrook. He firstly just quite neatly deals with the fact that a party's death doesn't automatically end all proceedings. There is the jurisdiction here to grant leave to appeal out of time. And that's really all there is to say on it. In terms of conditions to satisfy a Barder, there are 4 conditions to get leave to appeal. The first one being new events relied upon invalidated the fundamental assumption, so that if leave were given, the appeal would be certain or very likely to succeed. So really, the application for leave to appeal and the substantive appeal go hand in hand. The second is that new events had occurred within a relatively short time, probably less than a year. The third is that the application was made promptly. And the fourth is the equities darling point. We see it also in Section 37 of the Matrimonial Causes Act, that no genuine bona fide third parties are prejudiced. So Lord Brandon of Oakbrook gives the leading judgment, as I say, and just a couple of points to note apart from these conditions. He looked, really the starting point is what is the fundamental assumption behind the order? And in this case, the fundamental assumption is to provide a home for the wife and the children with the expectation that they would be living there for the foreseeable future. And importantly, there was no expectation, absolutely no anticipation whatsoever, that the wife was about to do what she did. So this is the case that gives us the precedent for a supervening event to invalidate the fundamental assumptions underlying the order, which justifies an appeal out of time. Really, putting aside legal principles, you might think, well, actually, this is a bit of a no-brainer in this case, but it does get more complicated. And I look at a couple of post-Barder cases. I'll give you two successful ones and one unsuccessful one. The first that I want to look at is the 2016 case. Again, just the very brief facts. The wife was a very wealthy heiress. There were mostly trust assets. Nearly everything was in trust apart from the family home, which was part in trust and part in the wife's name. There was a prenup, but actually they didn't end up using it. The parties separated in 2014, and by all accounts, it hit the husband very hard. Through negotiations between solicitors, they reached an agreement that the husband would receive 17.34 million in two tranches. And the first tranche was duly paid. But 22 days after the order was made, the husband committed suicide, leaving his estate to his adult siblings. Now, you might be thinking, well, this all sounds actually quite familiar, but the husband's siblings argued this foreseeability angle. They said, well, actually, the husband's death was anticipated. And this foreseeability point was something that I'll come on to the case of Cornick from 1994, but that really fleshed out the need for unforeseeability to be part of the supervening event. Of course, also what's interesting about WA is that it's post-white and white. So you've got the idea that of a sharing award versus a needs award. And the husband's estate rather fairly said, well, look, if it's a sharing award, then it's his money to do with as he will. And it shouldn't be, the award shouldn't be effectively reversed. Of course, it is different if it's a needs award. In the end, the wife succeeded. The court reduced the total lump sum payable overall to 5 million. So actually the husband's estate had to reimburse the wife some 3.67 million. And the court justified that 5 million by saying, even if they'd known that the husband had a month to live, the court wouldn't have ordered zero, applying both the sharing principle and needs. But the court did accept that the award was primarily needs-based, given, of course, the fact that the assets were almost entirely non-matrimonial. And the court wasn't satisfied that suicide was foreseeable. So successful, but didn't completely eradicate the monies paid. The next case is Critchell and Critchell. And in this case, the Barder event was said to be an inheritance. So the only asset in the case was a family home, 175k equity, and they agreed a measure order, triggers being child reaching 18 or finishing secondary education, the usual triggers, and the husband had a 45% charge. Post-separation, the husband buys a house with a loan, substantial loan, £85,000 from his father. Within a month of the order, the husband's father died, leaving him an inheritance of £180,000 plus extinguishing the loan that enabled him to buy his house. So that death was completely unforeseen. And the wife said, this is Bada. The first instance judge agreed and removed the charge. The husband appealed, but he lost, and it was a Barder event. And again, it's looking at the fundamental assumptions behind the order, that the charge was there because the resources were so limited. It's about giving effect to fairness. But then after the event, the husband's adequately housed. He doesn't have the loan to his father, and actually he's got more by way of inheritance, and there was equity in the family home. Of course, it's fact specific, and it's worth noting that just like with WA, the supervening event was around a month after the order. So really, really close to the events. An unsuccessful case I want to talk about is Richardson and Richardson. And actually, there are two alleged Barder events in this case. As I set out in the slide, the first is that 6 weeks after the final order, the wife died unexpectedly. And 12 weeks after the final order, the husband found out that a claim against the family business was likely not insured. Just for context, they ran a hotel business, and 5 years prior to the order, a child had a horrible accident, fell out a window and suffered brain damage. And the damages claim wasn't dealt with in the final hearing because they both thought that the claim was covered by insurance. But the husband then finds out two things. He finds out, firstly, that there was a limitation on the insurance to 2 million when the child's claim was for 3 million. But more importantly, he finds out that the insurer had avoided the policy. So the husband says the wife's death and the revelation about the insurance are two Barder events. In the alternative, he pleads that the insurance was a vitiating factor by way of mistake, and the appeal was allowed on the basis of the vitiating factor, not Bada. And the court is coming back to the sharing point that I mentioned under W&A. The court said that a spouse just dying unexpectedly isn't enough, even though it does seem to be a theme in these authorities. The division of the assets was predicated on sharing. The wife got 47.5% only to reflect the illiquidity slightly of what the husband had received. So it's clear that that was the thinking. And the case talks about the fact that the marital pot was a product of the wife's hard work as much as the husband's, and it wouldn't be right that the husband would just be able to effectively claw back what was the wife's share. She's entitled to leave it to whoever she wants. In terms of the insurance limitation, the court used the phrase that comes up again and again in these authorities, known unknowns, the Rumsfeldian expression. And the court basically found that the husband should have known about the insurance limitation, but couldn't have been expected to know that the insurer had avoided the policy. And so on that basis, the appeal succeeded. Lord Justice Thorpe gave a message at the end of this case, which I've put on the slide. It's very, very clear that these authorities are very, these cases, successful Barder cases, are few and far between. Moving on then to a couple of COVID similar Barder cases, we'll take one where there was massive economic improvement and one where there was a massive economic downturn. So Cornick and Cornick, the husband's shares skyrocketed post the order. And just to give a bit of context, they were worth £2.17 at the time of the order. A few months later, in November 1993, they reached £7.23 per share. So it's an absolutely massive increase. The order, it was not an order by consent, it was a final order. There was an order for periodical payments and a lump sum order designed to give the wife 51%. So the husband's shares skyrocket, and the wife seeks to appeal out of time because she says, well, this has fundamentally altered the balance of the assets of the case, and it's not fair. The appeal was unsuccessful, and a young Mrs. Justice Hale gave judgment, and she said that natural processes of price fluctuation, however dramatic, are effectively not a Barder event, and she emphasized that you have to look at the foreseeability of change. In the judgment, she gives three scenarios of a change in asset value. So where there's the natural processes of price fluctuation, the court shouldn't intervene. That's scenario number one. Scenario number two is where wrong value was put on the asset at the time of the final hearing. That can give rise to an application, but that's more along the lines of a non-disclosure or a misrepresentation argument. And the third is this: something unforeseen alters value so dramatically so as to bring about a substantial change in the balance of the assets from the order. That can be a Barder event, not automatically, but it can be. Mr. Justice Hale actually really summed up the case as being what's being sought here is effectively a variation due to a change of circumstances. That isn't what a Barder event is. And she was also very conscious of the floodgates argument. But for context, it was noted in dismissing the appeal that the wife still had a periodical payments order that obviously is variable. So she was protected there. And something that I'll come on to that was considered in this case as well was whether a Barder event has to be a specific event or whether it can be a series of developments, for example, the progression of economic downturn as a result of COVID. The other case is Myerson and Myerson, which I'm sure everyone's familiar with because it's the quintessential case that people have looked at when looking at a COVID application, because this was in light of the financial crash. And unlike in Cornick, the husband's shares plummeted rather than skyrocketing. So at FDR, the parties reached an agreement. And again, it's important that it was a consent order. The assets were divided 53-43 in the husband's favor. That saw the wife getting 11 million, mostly lump sum payable in installments plus a property. The husband retained a few properties, but principally a shareholding in a company. So he's chosen to retain the speculative assets and given the wife the copper-bottomed assets, which of course then justifies the departure from equality in his favor. He pays the first lump sum of 7 million, but then the financial crash hits and the shareholding just plummets. By the time of the appeal, the shares were worth so little that actually, if the husband complied with the order, he would have been left with nothing. But even then, the Court of Appeal, sorry, not the Court of Appeal, the High Court, granted permission, but dismissed the appeal. And there's two main points to take here. Firstly, it's reiterating what Mr. Justice Hale said in Cornick, that natural processes of price fluctuations, however dramatic, are not Barder events. But as I said, also the fact that the husband chose this structure, it's the Wells and Wells argument. He elected to retain the more speculative assets, and he took a risk. They could have done really well, in which case we'd be in a Cornick situation, but actually they went the other way. And so I do think that there is some weight to the fact that it was a consent order. Coming then to the present day, we have a couple of examples of COVID case law. The first is FRB and DCA number 3. Given that it's number 3 and there's also number 4, I think it's fair to say that it is gladiatorial litigation. And the judgment of Miss Justice Cohen, again, I'll give you the basic facts just for context. There was a final hearing for 3 weeks in January and February 2020. Judgment was handed down on the 30th of March, having been circulated at the end of February. So you can see already from the timing that we're right on the precipice here in terms of the plunge into COVID. The order was for the husband to pay the wife 64 million, being the family home and lump sums by installments totaling 49 million. So 30 million in 6 months and 19 million within 18 months. At hearing just before formal hand down to tweak a couple of issues with the judgment, the husband's team orally applied to defer judgment until September 2020, just completely defer it due to COVID-19. That was rejected. Husband appealed. He was refused permission. But although he did pay periodical payments, he didn't transfer the house. He didn't pay the lump sums. On the 28th of September, he applied to vary the order as to both the timing of the lump sums and quantum. The wife also applied to upwardly vary maintenance for interest and for legal services provision. Number 3 is dealing with the application to vary. The husband says, vary the lump sum, because it's a lump sum by installments, so it is variable under Section 31, or set it aside and requantify on a Barder basis. But the application was dismissed, and really it's not one of principle. It's the fact that there wasn't really any evidence from the husband of the economic impact of COVID. And this was in circumstances where he wasn't exactly full and frank in the original proceedings. So Mr. Justice Cohen wasn't satisfied, but as I say, primarily due to evidence. And he did note that the husband might find a bit more leniency from the court in terms of looking at the timing of lump sums. But it really, what we take from this is it goes without saying that if you're going to argue a significant change of circumstances, you have to prove it. The more helpful case is HWWA, a judgment of His Honour Judge Kloss. And I like this trend in judgments now that they contextualize the judgment by asking the seminal question: is COVID-19 pandemic and its impact upon the value of a key asset a sufficient ground to set aside a financial remedy consent order? Yes, is the answer in brief, but not in this case. Again, just looking at the basic facts, because it's important looking at foreseeability. The parties settled at FDR. Again, note that this was a consent order, not an imposed order. The FDR was on the 12th of March, 2020. So again, we're right on the cusp of things. And even then, everyone knew what the direction we were headed, not crystal clear, but we knew something serious was going on. The settlement was for a series of lump sums to the wife, totaling 1 million, to be paid by the 12th of April 2022. The first lump sum of 740,000 by the 10th of June 2020. The husband was going to retain his company, the wife transferring her shareholding in it. So again, we've got this common theme here of the complaining party retaining the speculative assets. So on the 5th of June, the husband applies to stay the lump sum payment relying on COVID. He doesn't pay it, and so the wife applies to enforce. The husband then on the 2nd of November applied to set aside the order, relying on Bada, saying that COVID-19 is a completely unforeseen event. He says that there's been such a substantial change in the value of the family company and that he couldn't possibly raise the money to pay the lump sums. The wife, obviously, as you would, referred to Myerson to basically knock this out on principle, but His Honour Judge Kloss wasn't persuaded. He said the COVID-19 pandemic, this is paragraph 85, by the way, the COVID-19 pandemic is an extraordinary event, different in nature and scale to any similar world event in the lifetime of the parties. This is not an issue of market volatility, which is periodically experienced. Neither is it a national issue with predictable localized causes. It is akin to a war with tentacles spreading across the world. I therefore find that in principle, the COVID-19 pandemic can open the door to a successful Barder claim. So that's really the answer to the question. Then in terms of the context of the case, I gave you the basic facts, the timing of the settlement, foreseeability is obviously going to be key. And His Honour Judge Kloss applied DB and DLJ, and he applied the subjective test, put himself in the shoes of the husband at the time, the husband with his specific knowledge. He said the question is posed by the court standing retrospectively in the shoes of the actors and asking itself whether the then future, but by now past, event could reasonably have been predicted. The husband's barrister said, well, do we even know what he was supposed to have predicted? Because we're still in the middle of this. But the judge wasn't persuaded by that, because he said that there's got to come a point where the husband can reasonably foresee enough to know that he has to make the application. Again, it comes back to the known unknowns point. His Honour Judge Kloss formulated the test. He said that could the husband have reasonably foreseen a risk that the COVID-19 pandemic might have a significant impact on the trading position of the company? And the judge found yes, the husband could have known. It was a global company. The husband was skiing just before the FDR, so perhaps was slightly relaxed about things, but actually he did have the knowledge, he did have the expertise to be aware that the pandemic would have had an impact. And so the judge found the appeal, the application failed at the foreseeability hurdle. The judge for belt and braces went on actually to look at the economic impact and decided that the financial change in the company wasn't enough either, primarily because he said with a Barder event, you've got to look at the long term. You can't just take a snapshot and say, okay, things are doing really badly at the moment, it's Barder. You've got to look at, well, will the company bounce back? How will it be performing in a year, 2 years? And unfortunately for the husband, he'd provided some rather optimistic forecasts to the bank, but not disclosed them until day 2 of the hearing, which then completely contradicted his evidence. So just a couple of concluding points on this before I move on to variation. There's an argument that comes up quite a lot in these cases that, well, it can't be Barder because you haven't identified a specific event. As I said, it's addressed by Mr. Justice Hale in Cornick and in Myerson. Developments can be a Barder event. You've just got to link it all together. In terms of applications now, the reality is that I would have thought it's highly unlikely that a Barder event would succeed, a Barder application would succeed now, because one of the conditions that the application needs to be made promptly, i.e. within a year, which takes us comfortably. A year ago, we were well into lockdown. So I think foreseeability is going to be a real problem. Of course, you could argue deferred economic impact of COVID, but again, you would have thought the application would have been made by now. But I doubt we'll hear the last of this, and I'm sure there are going to be many fascinating decisions coming our way. Moving on to variation, I won't dwell quite as long on this because I know that everyone's familiar with variation. Obviously, we look at Section 31 of the Matrimonial Causes Act. In terms of what we can vary, primarily it's income-based awards like maintenance, with a few capital exceptions like lump sums by instalments. As to lump sums, it's worth noting what was said in Westbury and Sampson, that varying the quantum of a lump sum on a Section 31 application is akin to making a Barder application. You have to show an unimaginable change. And so the threshold is really high. But as Mr. Justice Cohen said in FRB, you're going to find more leniency in terms of timing. So in terms of what has to be shown, the court will look at all the circumstances of the case, but will particularly look at any change between the original decision or agreement for the order and the application. Obvious examples from case law are cohabitation. In terms of maintenance, and it's relevant for any COVID-based variation, we know that maintenance orders are made to address relationship-generated need. And we also know that there's a limit to that. As it was said in North and North, the maintenance payer is not the insurer against all hazards. So if there's a need occasioned by something that's not connected to the relationship, you may well struggle. Looking at COVID, well, lump sums, again, come back to FRB, we come back to Westbury. In terms of quantum, it is going to be an uphill struggle. But timing, you would have thought you'd get much more sympathy, and it can really go to the point of the legacy of COVID here, that okay, we thought we could weather the storm, but actually we're not recovering how we expected. In terms of maintenance, you've got two sides of the courtroom here. You've got the ability to pay, and then you've got needs. The ability to pay is likely to be an effective reason, albeit possibly only in the short term. If your income has gone down as a result of COVID and there's no sign of it rallying, then you could say that COVID would justify a variation. But just like with the Barder event, if it's a blip, if your income's gone down but it is rallying, it's going to be harder. COVID's been like a hammer blow to the economy, but we are seeing green shoots. We are seeing some recovery, and I would thought the court would be reluctant to vary an order when actually income has gone down but is going up again. What it may do is justify remitting arrears, for example. In terms of needs, it comes back to the North and North point. If you lose your job because of COVID, is that relationship generated need? I think it's quite hard to argue personally. To make that argument, it would, I think, conflict really quite strongly with what was said in North and North. There is a case that deals with this, but before I go on to that, I want to go back to HW and WW for a minute. As I said at the outset, another method of variation is the thwaite jurisdiction. It was actually raised by His Honour Judge Kloss in HW and WW and said, look, does anyone want to apply under this or liberty to apply? Neither of the legal teams did. Liberty to apply obviously doesn't give rise to any additional powers or jurisdictions. It's just implementation. But there is the thwaite jurisdiction. The case of thwaite, very briefly, a consent order was made for the husband to transfer the family home to the wife on the basis that she would be moving from Australia to the UK to live in it. She actually only returned briefly. Then she went back to Australia before the property was transferred. So the order was still executory. It was yet to be implemented. And the husband applied, and the Court of Appeal didn't enforce the transfer. So what we can take from thwaite is that the court has the power to vary an executory order, and the test is whether it would be unfair to hold a party to the original order's terms where there has been a significant change of circumstances. So again, not completely foreign to the Bada test. In terms of how rare these cases should be, well, there's conflict at first instance. In SR and HR, Mr. Justice Mostyn said we should use this jurisdiction very cautiously and very conservatively. However, that conflicts with the 2016 case of Bezeliansky, which was permission to appeal only, so not binding, but clearly highly persuasive. Mrs. Justice Roberts in US and SR was not on the same page as Mr. Justice Mostyn in SR and HR, and gave a decision much more in line with Bezeliansky. The latest word is from Mrs. Justice Leven in the case on the slide, Kaczynski and Pardee. And for anyone looking for an up-to-date summary of the case law, go no further than paragraph 25 of the judgment. It's very helpful. Mrs. Justice Leven was quite clear that she's not remotely swayed by what Mr. Justice Mostyn said in SR and HR. She very much follows the Bezeliansky line of judgment. She sets herself a two-stage test. Has there been a significant and relevant change of circumstances since the order? If so, would it be inequitable not to vary the order? So clearly, if you can satisfy that without any gloss from SR and HR, you can vary it. But again, it's only if the order remains executory. I'm looking at the time and I can hear you crying out for one final case. I should give it AJC and PJP from Deputy District Judge Hodson, sitting at the Central Family Court. This is a decision about an application to upwardly vary a nominal maintenance order. Again, like His Honour Judge Kloss in HW and WW, Deputy District Judge Hodson very helpfully contextualizes the judgment by posing the question that I set out in the slide. Again, some context. The original order was made in 2012. Sorry, 2012. Got a bit overexcited there. The wife sought a substantive order, even though on her own case, she could be self-sufficient again in relatively short order. So effectively, she's looking at the nominal order as an emergency fund. The wife's application was not successful. There is some interesting discussion from the Deputy District Judge about the rather curious beast that is the nominal order, about the fact that it's almost doesn't exist in some parts of the country, and he finds that in most parts of the world there isn't a similar concept. But he was the view, just in terms of variation, he was of the view that there is a difference to dealing with a variation of a nominal order versus a substantive order. In terms of a nominal order, he felt that only with a significant change of circumstances will variation be justified, so a higher threshold. Obviously, this is first instance, but it's a good judgment, and it's worth having regard to. But I mention it really because it goes to this point of relationship-generated need and the difficulty in bringing an application due to COVID. Paragraphs 42 and 43, nearly the final paragraphs of the judgment, merit considering. And I've set out at the start of it, misfortune or unexpected developments in life is the nature of life. Life never goes according to plan. He goes on, losing a job through the consequences of the virus when one had a job at the time of settlement a decade earlier cannot be ascribed to relationship-generated disadvantage or even a loose causal connection. And so this is the difficulty that one might find themselves in if you're trying to argue that well, because of COVID, I should have an increase in my spousal maintenance. So just to briefly conclude on variation, then the initial signs are that if you are going to bring a variation application and you are the maintenance recipient, the recipient of the maintenance, you're going to really have to clearly justify it on a needs basis and that causal connection between your current circumstances and relationship generated need. In terms of if you're the maintenance payer, a short-term blip is unlikely, it would seem, to satisfy the court that there should be a long-term variation in maintenance. The court, I think, would take a more long-term approach like Bada and look at, say it's a company, look at projected performance and look at how it might get back to things. But that's just my opinion. That I'm conscious of not taking up everyone's lunchtime, so I'll say thank you very much for listening. And I've done a plug on that page for the Family Law podcast as well. Please do listen. We've just finished series 3. It's really quite interesting, or certainly I think so anyway. I've had one question in advance, which was, in what circumstances would COVID-19 be a Barder event? Which is obviously the $1 million question. And we're really in scenario number 3 outlined by Mrs. Justice Hale in Cornick. And it's really, I think foreseeability is going to be the real problem here. Putting aside financial change, you're going to have to establish that the pandemic, the economic impact of the pandemic was not foreseeable. And I say that, as I said, because we're well over a year after the start of the pandemic. Maybe if settlement was entered into in, say, January 2020, and there's been a dramatic change, you could make, but then you haven't made the application promptly, so you're likely to fail at that point. And in terms of financial change, it comes back to where the husband fell down in HW and WW, that yes, the business may have been on a downturn, but actually it was predicted to get back to profitable levels. I think it was saying that it would get back to its 2018 profits by 2022. So actually not the irrevocable change that it was being presented as. And I think in terms of Barder event, you're really going to be looking at irreversible change to a key asset, even adopting that long-term view. So that's my view on when COVID would be a Barder event. I don't know whether there are any other questions. There is a Q&A function on this thing, but I'll give it, say, a couple of minutes, but otherwise, if there are no questions, then I'll let everyone get back to their lunch. I had one question. If you apply to various spousal maintenance payments upwards, not from nominal, do you have a better chance as a result of COVID? So Deputy Discharge Hodgson did say in the AJC case that there is a difference between nominal and substantive. So yes, I would say that the court's going to look more kindly on that an application to very substantive maintenance rather than nominal, but you still have this issue of justifying the change in terms of relationship generated need. But if you read the judgment, a couple of the arguments, like the fact that the husband would never have actually budgeted for paying maintenance, that goes out the window, because of course, if you're already paying maintenance, you have budgeted for it. So yes, I do think you stand a better chance, but far from certain. I think that's no more questions. Well, I think I'll draw it to an end there, just to savour everyone their lunchtime. Thank you very much for coming. It's much appreciated. And tune in next time. Thank you very much. Goodbye.